for this crime.
He's on parole for possession.
Oh, yeah, I mean,
Oh, yeah.
parole hold. I'm thinking of parole hold.
Oh, I was like, how could it be on? Very confused for a minute. Good morning, sir. Are you Anthony Cassio?
Yes, ma'am. Good morning, Saturday.
And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Cassio, in cause number 26 DCCR 0902, you're charged with the state jail felony offense of tampering with electronic monitoring device. And that's from March 29th of 2026. And how do you plead to that charge?
I was talking to my lawyer about.
It's either guilty or not guilty. Or go to, I mean, if not guilty, you can go to trial, or if you did it, it's guilty. Are you pleading guilty freely and voluntarily? And because you did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am. I had a few questions.
What's your questions?
I was told that I wasn't eligible for a 1244 because of my prior, but I only have one prior.
So it's not a matter of if you're eligible or not. It's a matter of if that's what the state's offer is, and it is not that. This is what the offer is. So it's you either, again, take this offer or go to trial.
Take me.
Any other questions? So before you signed these, you went over with them with Mr. Parker though, right?
Yes, ma'am.
All right. And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Cassio is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of tampering with electronic monitoring device. Sentence you in accordance with your agreement to a term of 1 year in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows this was an agreement that I followed, and so you did waive your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker.
Yes, ma'am.
All right, good luck to you, sir. You can go back with the bailiff. Sean Johnson.
It's rejection. He may be. This.
Ooh, a snowboarder. Isn't that his name?
Huh?
Yeah, the snowboarder.
Oh. I was thinking of the gymnast.
Oh, yeah, probably. Okay,
That's what I thought.
no, getting confused.
Sean White.
Yeah.
Right. Sean Johnson is the gymnast. Probably not the same, definitely. Good morning, sir. Are you Sean Joe Johnson?
Yes, ma'am.
And Mr. Johnson, in cause number 26 DCCR 0924, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon from March 6th of 2026. Your indictment alleges that you were previously convicted of burglary of a habitation, a second-degree felony, July 8th of 2016. And then after that was final, you were again convicted of burglary of a habitation, a second-degree felony, February 15th of 2017. And what that means, sir, is that if you go to trial and you're found guilty, you would be considered a habitual offender with a minimum punishment of 25 years in prison, up to 99 years or life. Do you understand?
Yes, ma'am.
And I have here on the tablet a plea bargain rejection that you've signed with Mr. Parker, and I'm guessing you guys, it says months are checked off.
Oh, I'm
guessing
sorry.
it should be years.
I'm apologize. Yeah.
So it shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 12-year term in prison. You have every right to reject that offer and have your case set for trial. Just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you want to plead guilty. Do you understand all that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, we'll get that done. Mr. Johnson, Mr. Parker has been appointed to represent you. He's one of the cases. He's one of the lawyers who handles a lot of cases for me here as a court-appointed attorney. With your permission, I can release him and appoint a new attorney who could begin preparation for trial a little quicker. Is that okay with you?
I'm gonna do a turn.
So I'm going to release Mr. Parker. We will appoint someone today. Mr. Johnson, they should begin preparation for trial very soon. Mr. Smith, is there any reason to believe or anything that you're waiting on that offer would be reduced with a different attorney? So I do want to make sure you understand that a different attorney is not going to necessarily get you a different deal. And that typically after today, I don't take those deals that you've already turned down. If something comes up that's different that your attorney doesn't know or the DA, then I'll consider it. But whoever that is will be out to see you very soon and begin preparation for trial.
Yeah.
All right, you can go back with the bailiff.
Look. All the other one I have is a Jericho Thomas. It's likely to be a rejection, but I need to I haven't got the video yet.
Okay, do you want me to bring them out or just,
It doesn't matter to me, Judge.
you can just let them know that we're going to reset it for you
Okay.
to get the
I
video.
know-
Jericho Thomas, they'll just say to get the video that way. Thank you, ma'am. See, Miss Holmes, you got Stormy Fulwell.
Over the motion, we can do an updated PSA.
I think you need to know exactly what you're gonna do on this one, though.
Yeah.
Oh, I do. Y'all do?
Mhm.
Well, how would you prejudge? Is it that clear?
She's very clear.
Oh.
This is one of those special drug things that the minimum is 10. But she pled.
Garrett, close down. I'm getting the video ready.
She's with the child.
She's been to St. Pete twice.
Good morning. Are you Stormy Fulwell? And will your client waive the formal reading of the motion?
Yes, Your Honor.
Ms. Fulwell, raise your right hand, please, ma'am. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You can put your hand down. Ms. Fulwell, in cause number 21-38655, I have a motion to revoke your community supervision. Shows that you were placed on probation January 26th of 2022 for possession with intent to deliver a controlled substance, a first-degree felony. And that was a 10-year term in prison that was probated for 10 years. Is that correct? The motion alleges that you violated your probation. It alleges in count 1 that you provided a urine sample January 26th of 2026 that tested positive for methamphetamine. Is that true or not true?
January 22nd.
January 22nd of 2026, excuse me. Is that true or not true?
Yes, sir.
True or not true? Thank you. Count 2 alleges that you failed to provide verification of performing the community service hours as required. And is that true or not true?
True.
Count 3 alleges that you failed to successfully complete the SafeP program and that you were unsuccessfully discharged from the supportive outpatient treatment on January 22nd of 2026 because you tested positive there for methamphetamine, amphetamine, and ecstasy. And is that true or not true?
True.
Count 4 alleges that you failed to submit to alcohol or drug screening January 21st and February 2nd of 2026. Is that true or not true? But that is not true. Count 5 alleges that you're behind in your court assessed fees as of February 6th of 2026 in the amount of $4,205. Is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, 3, and 5 freely and voluntarily? And did you plead true to those counts because they're actually true? All right, then I'm going to find that you entered your pleas of true to counts 1, 2, 3, and 5 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. I'm going to reset your case for sentencing and ask the probation department to do an updated report that'll give me more information about what's been going on. Also, if there's anything that you think is important for me to know, get that information to Ms. Holmes and she'll present it to me on your behalf when we come back. All right, you can go back with the bailiff. Thank you for being here, ma'am.
Ma'am.
Stop. Good morning, sir. Are you Jasmine Tyrone Hancock?
Yes, Mom.
And Mr. Hancock, in cause number 25, DCCR 0737, you're charged with the state jail felony offense of evading arrest or detention with previous convictions. And that's from April 22nd of 2025. The indictment alleges that you were previously convicted of evading arrest or detention August 9th of 2013. Some of these are with vehicles, which would make them different. Looks like we've got an evading with a vehicle, April 23rd of 2008, another evading with a vehicle, December 1st of 2008, and evading with previous convictions, June 12th of 2017, and evading also with previous convictions, June 12th of 2017, and evading with a motor vehicle, 2 cases on June 12th of 2017. Then the indictment further alleges that you were convicted of unlawful possession of a firearm by a felon, February 9th of 2009. Also possession of a controlled substance on that same day. And then after those were final, you were convicted of burglary of a habitation, June 12th of 2017. And what that means is that if you go to trial and you're found guilty and those prior convictions are true, the range of punishment would be that of a second-degree felony, which is between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
So in clause number 25, DCCR 0738, you are charged with the 3rd-degree felony offense of continuous violence against the family, and that's from April 26th of 2025. And it alleges those same prior felony convictions, which in this case means that if you go to trial and you're found guilty, the range of punishment would be that of a habitual offender, which is a minimum of 25 years in prison up to 99 years or life. Do you understand that as well? And then we've got cause numbers 25 DCCR 1233, which is another evading arrest or detention with previous convictions. And that's from August 5th of 2025. And then we've got 26 DCCR 1018, which is also an evading arrest or detention with previous convictions from March 18th of 2026. Those are both the same as that first one with those prior offense convictions that would make these second-degree felony offenses for punishment. You understand that? In all 4 of these cases, I have here on the tablet some plea bargain rejections that you've signed with Ms. Holmes, and it looks like the district attorney's office has made offers if you wanted to enter pleas of guilty. For the evading arrest or detention cases, it looks like it would be cause number 250737 and
I think I did.
1018. There would be 12-year terms in prison with dismissals in the other evading and that continuous family assault case. You have every right to reject those offers and have all of your cases set for trial. I want to make sure you understand what the possible consequences are if you go to trial and what your options are if you want to plead guilty.
Yes.
You understand all of that.
Yes.
I also want to make sure you understand that if you are found guilty on more than one of these, because they're different offense dates, there is the possibility that any sentence you receive on more than one could be stacked on top of each other. Do you understand that?
Yes.
And do you want to reject all of these, the offers on all of these cases and have them all set for trial?
Yes.
Mr. Nichols, is there any reason to believe that these offers would change or?
No, Your Honor.
So I do want to make sure you understand also, Mr. Hancock, that after today, I will not accept these plea agreements.
Yes.
Once your case goes on the trial docket, it goes to trial, or you can enter a plea either open to the court or to some different.
Yes, ma'am.
You understand all that?
Yes, ma'am.
All right, then we'll get it set on the trial docket. Mr. Hancock, Ms. Holmes has been appointed to represent you at this point. She's one of the attorneys who handles a lot of cases for me as a court-appointed attorney.
Yes.
With your permission, I can release her and appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
So, Ms. Holmes, I'll release you. We will appoint someone today. They should be out to see you at the jail very soon to begin preparation for trial.
Yes, ma'am.
All right, you can go back to the bailiff.
All right, Brenda, thank you.
All right. Art King, Ms. Holmes?
I don't know if we need them. This one, I had requested, that he be brought so we could watch the courthouse video.
Uh-huh.
And they said they needed Pam's approval and they would call me and let me know, but nobody's ever let me.
Who's told you that?
Her secretary, I don't know her name. Yeah. And so, and Iris told me, she said, well, I'm definitely gonna call you, let you know, but she never got back with me, so. I don't,
We don't need him. So I'm gonna reset it one more time. If you will make sure
Yeah, I'll tell him.
that, that's obviously required. I don't think
yeah,
we need to make some time. Miss French doesn't have to be
I know.
present. Just get that
We'll
video
get that
down
done.
here. Okay, we'll
We
get
just
that.
need
done.
it'll be another day.
Hang around, we'll see if we can just get
Okay,
to that.
okay.
Oh, yeah, hold them for a second, maybe. And if we can get that down here,
Yeah,
Maybe
definitely. I
we
want
can
to see
get
if we
you
can
in
do
the-
it today.
that'd be great. Okay, yeah, let's hold them for a minute. We'll see if we can get
Okay.
that video down here. Thank you, Mr. Nichols.
Yeah, sure.
I'll be that.
Okay, let's see. Ms.